US Namaskar and greetings to all. I'm going to present before you the selected judgments on IBC, that is Insolvency Bankruptcy Code, which took place during the first half of March 2026. There is one slide in this presentation which exclusively focuses on sea of changes that has been introduced with respect to valuation process. We are no more looking at only focusing on liquidation value. Now the focus is on both fair value and liquidation value. And it is no more international business standard. The code is focusing on replacement value, so which is absolutely different. So I hope with this, let me take you over to the main presentation. I hope you'll like it. Viewers, we are on the screen to section 237, which is appeal and revision. Before I start, I should say one thing. A diamond remains a diamond, irrespective of when you went on it. Same thing, same rule applies to a judgment. So long it is active, it is a diamond. So this particular case which we are going to discuss, doesn't relate to March. It was decided sometime in 2025. But since it came to my notice, it is my ardent duty to present it before you. Now, firstly, let us go to section 237, which deals with appeal and revision. The section says the High Court may exercise, so far as may be applicable, all powers conferred under Chapter so and so of the Code of Criminal Procedure 1973 on a High Court, as if a special court with the focal local limits of the jurisdiction of High Court, where a court session trying cases within the local limits of the jurisdiction of High Court. So it says that High Court holds the jurisdiction. Now let us come to the topic. The topic is a body, public or private, should not be categorized as amenable or not amenable to writ jurisdiction. A body, public or private, should not be categorized as amenable or not amenable to writ jurisdiction. The cases of Sobha versus Muthoot Finance Limited, Special Leave Petition 25 of Supreme Court. This also deals with Section 3, subsection 7. What is Section 3, subsection 7? It defines corporate person. Corporate person is defined as what? Corporate person means a company as defined in Clause 20 of Section 2 of Companies Act 2013, a limited liability partnership as defined in Clause N of Subsection 1 of Section 2 of Limited Liability Partnership Act 2008, or any other person incorporated with limited liability under any law for the time being in force, but shall not include a financial service provider. So financial service provider is not considered as a corporate person as far as IBC is concerned. And as we know, for financial service provider, insolvency bankruptcy proceedings can be instituted only through RBI. So let us go to the topics. Now, topic number 1 says NBFC companies are classified as financial service provider. We have had cases of Housing Development Finance Corporation Limited versus RHC Holding and Equitas Small Finance Bank Limited versus Jumbo Finvest, in which it was held categorically that a financial service provider, that is an NBFC or a bank, you cannot institute, you cannot bring in a Section 7 proceeding. Now let us go to this topic. Topic number 5. A writ mandamus or a writ in the nature of mandamus may be used on an NBFC in instance of denial of any rights is in connection with the public duty imposed on such body, the public law remedy can be enforced. What is the case? It is the same case. S. Soha versus Muthoot Finance Limited, SLP number so and so, Supreme Court. Now, this case pertains to a gold loan being availed by somebody during COVID-19 period. The money was not repaid, so Muthoot sold the gold. The party said, no, the money should be given back to her. They filed a writ at High Court. High Court did not accept the writ. They cancelled the writ and the matter went to Supreme Court. Now, the basic question why I have selected this case is, it appears that there are thousands of NBFC companies. And there is a common notion that you can do nothing as far as if an NBFC company does anything wrong, because it is impossible for RBI, Reserve Bank of India, to institute CIRP proceeding against whoever does wrong. We have seen in the case of Shrey, in the case of DHFL, that they have done it. But it is not possible for small NBFC companies. It is rather difficult. They do take action. So I would request, though every word of this, the excerpts of the judgment which I have used here is important. And I would request my viewers to please go through it. So I stop the screen share here and take you to the slide which I prepared for you. As I have written, as I have already discussed, as I have already mentioned the basic headlines. So I'm not going into that. I'm going into the highlights of the case which is there. Now, many of us do not know what is Mandamus. At least I don't know. I'm not a lawyer. So what is a Mandamus? And the answer is a judicial writ issued as a command to an inferior court or ordering a person to perform a public statutory duty. Understood? So Mandamus is clear. Now, what did Supreme Court say essentially? The court will not debate academic matters or concern itself with intricacies of trade and commerce. The difficulty will lie in demarcating the frontier between public law domain and the private law field. It is impossible to draw a line with precision. We do not want to attempt it. Private law and the law is segregated into two parts, public law and private law. It is very difficult to find, to draw a threshold in between. And invariably there are overlaps. So the court judges the thing in terms of from case to case. A limited liability company incorporated under Companies Act is not a public authority, nor is an unincorporated association like that of a jockey club. It is individuals or bodies entitled to the rights who are the beneficiaries of the protection provided by private law. This is very important. It is the individuals or bodies entitled to rights who are the beneficiaries of the protection of private laws. So individuals should get protected. The respondent herein cannot be called a public body. It has no duty towards public. Its duty is towards the account holders, which may include the borrowers having availed loan facility. A body, public or private, should not be categorized as amenable or not amenable to writ jurisdiction. So everybody is subject to writ jurisdiction. Now the Honorable Court has determined who are or against whom writ can be, or Article 226 can be exercised. A writ petition under Article 226 of the Constitution of India may be maintainable against one, the state government, authority, statutory body, an instrument or agency of the state, a company which is financed and owned by the state, a private body run substantially on state funding, a private body discharging public duty or positive obligation of public nature, and 8, a person or a body under liability to discharge any function under the statute, compel it to perform such statutory function. So it's a wide spectrum which is there. Although NBFC is bound to follow, now we come to the crux of it. Although an NBFC is bound to follow and abide by guidelines provided by Reserve Bank of India, yet those are regulatory measures to keep a check and provide guidelines, and not a participatory dominance or control over the affairs of the company. Reserve Bank of India guidelines are for general guideline, how they should perform. But it is not a participatory dominance or control over the affairs of the company. The company runs by itself. A scheduled bank cannot be termed as a company carrying on public function or public duty. This is extremely important. A scheduled bank cannot be termed as a company carrying on any public function or public duty. Banks are doing business. They are not doing charity. They are earning profit out of the money which we pay, deposit in bank, by lending it to others. So they are not performing any public function or public duty. Okay, when they implement government schemes and do this and that may be public duty. But under normal circumstances, they are not doing any public duty. A writ mandamus or a writ in the nature of mandamus may issue to a private body, but only where a public duty is cast upon such private body by a statute or statutory rule, and only to compel such body to perform its public duty. The denial of any right is in connection with the public duty imposed on such body. Public law remedy can be enforced. So if you deny a public duty, public law, violation of constitution, definitely remedy can be enforced. So even if under IBC you cannot issue a section 7, the court's door is always open. You can definitely bring in a writ petition. You can do against the NBFC or bank or financial institution. So there is no blanket protection as far as banks and financial institutions and NBFCs. So the public or the multitude is protected by the umbrella provided in the judiciary system. And this is very important. And that is why I call this judgment as a diamond, as a piece of diamond. That too, antique, beautiful diamond. And I would request my readers to go through this. So with this, we will move on to the next topic. Now we are on the topic of, or rather to say, we are in the dashboard of section 3, subsection 27, which deals with property. And this is a very critical definition. And since asset is not mentioned in Insolvency Bankruptcy Code definitions, property takes into its account the assets also. So this is a Supreme Court judgment. The basic topic which evolves out of this is protection of asset of a real estate project is of vital importance. We come to the case is Moniveda Consultants LLP and another versus Shahja's Development Private Limited and others. Civil appeal number so and so, Supreme Court. Though this is a 2022 judgment, this came out possibly last week itself. But to go into the background of the case, I'm not going into so much of details. See, in Mumbai, most of the properties that you see, many of the properties are built on slum rehabilitation. That is what people do, is there is a very strong slum rehabilitation authority, which allows promoters to develop the slum, to relocate the slum dwellers to another place, pay for their rent, etc., and then construct an alternative home for them. In order to do that, they get an additional space, which is called free sale component. And this I have covered in one of my podcasts. So free sale component, at which you can sell to others. So, and this is a very popular thing in Maharashtra, especially Mumbai. And invariably, there are a lot of jugglings and transfer of shares and this and that, because this is a very lucrative thing. In Mumbai, land is very costly. So considering that, the developers, uh, I would rather say the shareholding of developers, often people get into different kinds of arrangements and this and that. Then frankly speaking, if you go through this case, you will find, I mean, it took me almost about 15 minutes and I had to write down on a piece of paper what was the relation between this party and the other parties. So this is a very important read. And at the end of the day, you will, besides being enjoyable, it gives you a lot of earning and gives you an insight of what happens with SRA project development. And in IBC, you will get SRA project development, which will come with coupled with home buyers also. So that is why this case is relevant. So with this, I take you over to the slide which I have prepared for you. Now here too, we are coming with two topics. Though I have mentioned in 327 only one topic, but actually two topics evolved out of this, and both of which are very important. One is protection of asset of real estate project is of vital importance. Second is the case relating to oppression and mismanagement can continue under Companies Act 2013 despite proceedings under IBC. So this is absolutely something new, because we know that once IBC sets in, Companies Act has to take the back door. But here Supreme Court ruled otherwise. They said that the case relating to oppression and mismanagement to continue under the Companies Act 2013 despite proceedings under IBC. Now, here what happened was, as I told you, there was, it's like juggling a Pandora box. One takes the share of others, the other kicks some down. One party goes into uh, the court and asks for an interim order. The NCLT refuses to give the order. They go to NCLAT. NCLAT issues an interim or stay order, but that was not that was not abided by word. So the parties went to Supreme Court. So Supreme Court essentially, by order dated 16/12/2022, Supreme Court granted interim relief in terms of clause 6 of paragraph 17 of the impugned order, effectively extending the direction to the parties not to take any perceptive steps in the subject matter. Perceptive steps. Spenter Sun City Private Limited, in whose favor the project land has been conveyed, had been admitted to CIRP under Section 7 of Insolvency and Bankruptcy Code 2016 on 10/7/2024. By order of 15/7/2024, the Apex Court, after impleading the concerned entity through its IRP as respondent number 11, directed that no construction be carried out on the property which forms the subject matter of present proceedings. Why? Because there was litigations. So until and unless court gets to know the real fact, so they would obviously ask the person to develop, because court is unaware. Court has to judge whether Spenter Sun City Private Limited really had a development right or not. The restraint was intended to ensure that no irreversible changes were made to the project land, while the dispute regarding underlying corporate control and transaction remained unresolved. That's exactly what I told. By order dated 25/10/2024, permitted to undertake limited protective work, namely having the foundation in the excavated pits, construction of retaining walls, backfilling, and necessary barricade of the adjoining area. This is basics. They allowed Spender to do it. So what? And then the court, the paramount consideration is to ensure that the subject matter of the proceedings is preserved until the competent forum adjudicate the dispute. What is the dispute? Is the dispute under oppression and mismanagement under Companies Act 2013, which had been transferred to NCLAT. So the court permitted that, let the court decide. Till the court comes to a conclusion, nothing should happen to the land. No steps be taken which would alter the nature of the property or create further third-party interest therein. So this, though directly, this directly and indirectly affects IBC. Directly, I would say that definitely since SRA is involved, Spenta has come in, was doing the project, so there must have been a free sale element. So stopping Spenta from doing the development would stop the construction of the free sale unit also, free sale component also. And the court had asked SRA authorities to go and inspect the place and inform whether any substantive change has taken place to the property or not. So this case is extremely important and extremely relevant, because today's slum rehabilitation is a big thing. Whether in Mumbai, I don't know, it could be there in other parts of India also. But this is of extremely importance. And so I would request my viewers to please go through the judgment and peruse it, because this will enrich your knowledge. So with this, we move on to the next slide. Viewers, you can see on your screen the dashboard of Section 4 of IBC. Section 4 does not normally feature in our podcast. This is our section featuring in the definitions of IBC. So we are coming to topic number 11, which says that when a winding up petition gets transferred from High Court to NCLAT, it transforms into a proceeding under Section 7 or 9 of IBC, and thus threshold limit of under Section 4 must be complied. The cases of Mr. Naveen Ashok Kumar Ashwini versus Falcon Industries Limited, and another company appeal number so-and-so NCLAT. This is a late February judgment which I could not cover in my earlier podcast, and so I'm covering this in this video. This is a very interesting case in which Gujarat High Court transferred a petition to NCLAT, and NCLAT took up various points like whether a transfer of the winding up petition, which has already admitted by High Court of Gujarat, the adjudicating authority, while hearing the Section 9 application, has to proceed from the stage, that is, from the stage of admission, or has to pass an order under Section 7 or 9 application. Whether operational creditor who has converted winding up petition in Section 9 application by filing Form 5 has to satisfy necessary conditions for admission of Section 9 application. Number 3, whether threshold for TP number 2 of 22 transferred by High Court to NCLAT shall be ₹1 lakh, or the operational creditor has to fulfill the threshold of ₹1 crore as applicable with effect from 4/3/2020. Number 4, whether application filed by operational creditor, the threshold of ₹1 crore was met on adding interest of 24% per annum claimed by the applicant. Number 5, whether there was a pre-existing dispute between the parties so as to reject the application by operational creditor. NCLAT has answered the questions, has given this verdict based on questions like question 1 and 2, question 3 and 4 and question 5. So this is a very interesting read and an offbeat judgment. And I feel the viewers should go through this. The excerpts which are featuring in the website, on the website. So with this, I take you over to the slide which I prepared for you. Headlines say the winding up petition CP number 240 of 2004 was filed by operational creditor in the High Court of Gujarat, claiming principal and interest of 7,62,500 along with interest at the rate of 24% per annum. The company petition subsequently came to be transferred by the Gujarat High Court by order dated 25/4/2021, relying on the judgment of Honorable Supreme Court in Action Ispat Power Limited versus Sham Metallics Energy 2021, SCC 641. The proceedings so transferred from High Court shall be dealt with by tribunal as an application for initiation of corporate insolvency resolution process under the Insolvency and Bankruptcy Code 2016. It does not remain a company petition anymore. It becomes a petition under Insolvency Bankruptcy Code. So Companies Act goes aside. Insolvency Bankruptcy, the sections of Insolvency Bankruptcy Code prevails now. Thus, the operational creditor has to fulfill the threshold limit as per amended section 4 of Insolvency Bankruptcy Code, which is specifically noticed in order dated 6/4/2022. The mere fact that winding up petition was admitted by Gujarat High Court while its order dated 11/12/2006 could not be read as to mean that Section 9 application in which it was converted after transferring has to be automatically admitted. So here, Companies Act is no more there. There is Insolvency Bankruptcy Code, and it has to follow the dictum of Insolvency Bankruptcy Code. The initial requirement for minimum amount of default was 1 lakh, which was subsequently enhanced to rupees 1 crore with effect from 24/3/2020. And the case was transferred when? 25/4/2021. So there is no question that the threshold limit will apply. Now, coming to the question of interest, the court observed that there is no agreement between the parties or any act on part of the corporate debtor that at any point of time, which proves that they accepted the interest on delayed payment. As per account confirmation letter dated 3/3/2004, which was duly signed by the corporate debtor, mentioned outstanding at 7,62,500 as on 28/2/2004. So the interest, since it is not agreed mutually between the parties, the interest is not to be considered, as held in many judgments of NCLAT. So interest was not confirmed. So insolvency, the question of admitting it under Section 9 of Insolvency Bankruptcy Code was out of question. However, in the order of Gujarat High Court has mentioned that the corporate debtor should pay 4.5 lakhs with interest. And so the court said that the amount of 4.5 lakhs with interest as directed above be paid by the operational creditor by the appellant within a period of 30 days from this order. If the claim of interest is not included, the principal amount is only 7,62,500, which does not fulfill the threshold of 1 crore. And the case was dismissed. So this is a new twist. Or rather, I wouldn't call it a new twist. But this is what we need to understand, that if a case is transferred from High Court to Insolvency Bankruptcy Code, NCLT, the IBC laws will prevail, not insolvency. And it is not the compulsion on part of NCLT to admit the case. So this is what makes this case exceptional. So with this, we will move on to the next slide. Viewers, you can see on your screen the dashboard of Section 5, subsection 8, which deals with financial debt. We have come across this particular subsection of Section 5 in the definition clause multiple times. We're coming to topic number 77, which says that as long as an allottee pays consideration and puts in money for purchase of units, this unit will have the effect of commercial effect of borrowing. The cases of Tejinder Pal Sethia versus Sri Arvind Kumar R. Civil Appeal so NCLAT. Let us go into the judgment. In this case, what happened was an allottee raised objection pertaining to a claim of a financial creditor. And there were two questions. One is, as an allottee, does he have a right to raise a claim? Because we know that when a CIRP is instituted or at the time of instituting, there has to be either 10% of the total voters or 100, whichever being lower. So this was, of course, CRP had already commenced. The plan was at resolution stage. But still then the question did arise as to whether he has the locus. Secondly, the question was whether it was a genuine ground to raise the claim. So this is no doubt a different kind of a case and worth going through the exams. Let me stop the screen share here and take you to the slide share. Now there are two elements. Though I have put in only one topic, there are actually two topics evolved out of this. One is so long as an allottee pays consideration and puts in money for the purchase of units, this will have the commercial effect of borrowing. The second is that IBC does not discriminate between a home buyer who purchases a unit for self-use or purchases multiple units for commercial purposes. So this is a new thing which we are hearing. Now, what did the court say? Court said that the appellant has inordinately preened into the recital clauses of the agreement deliberately to obfuscate the status of the respondent 2 and 3 from that the allottee, that the non-allottee and non-financial creditor in class. Now, existence due to a creditor in a class can be established through agreement for sale, letter of allotment, receipt payment made, and any other document evidencing the existence of debt. In the present case, the respondent 2 and 3 have clearly established the same and has been noted by the adjudicating authority in a tabular chart. Now comes the vital part. As long as an allottee pays consideration, puts in money for the purchase of units, this will have effect of commercial borrowing. Consequently, such unit purchaser is clearly entitled to be treated as a financial creditor in terms of Section 5, subsection 8, subclause F of IBC, which would establish or enable him to make claim in terms of Section 3, subsection 6 of IBC. Section 3, subsection 6 deals with claim. The legislature has consciously limited the applicability of RERA Act, specifically in respect of definition of the term allottee and real estate project, is inserted in explanation 2 of Section 5.8 by IBC, Second Amendment Act 2018. There is no infirmity on the part of the adjudicating authority to have upheld the decision of RP, to have admitted the claims of the respondents. IBC does not discriminate between home buyer who purchases units for self-use or purchase of multiple units for commercial purposes. Section 15 of RERA Act expressly contemplates that a single allottee may book multiple apartments or plots in a project, and there is no restriction on the third-party sales or multiple bookings by the same entity. So, NCLAT did not find any defect in the judgment. But we have to remember one thing here. I had mentioned to you in one of my podcasts, what is the meaning, a homeowner has to own a home. And what is a home? Home is a residential unit. A home has to be used for residential purposes. The residential purposes can become commercial also. Like if you are renting out a place for PG accommodation, not a hotel or a motel. But if for residential purposes you are doing it, it remains as residential. So a company, if it buys flats for housing staffs, this is perfectly residential. So you will remember that I had spoken of state of Karnataka and another versus Tagher Vasudeva Ambarish and another civil appeal number 7846 of 2023 Supreme Court judgment, which is not a very late judgment. And you will find it in my earlier podcast. And in which it was categorically Supreme Court held that residential dwelling means a residential accommodation, but does not include hotel, motel, inn, guest house, campsite, lodge, houseboat, or like places meant for temporary stay. So if a claimant, homeowner, is buying a property for commercial use, but using it for a temporary stay, well, the court may take it otherwise. So this is an important lesson we should keep in mind. And with this, I take you over to the next slide. Here on the dashboard of Section 9 of IBC, which deals with insolvency instituted by operational creditors. I normally cases instituted by operational creditors invariably end in pre-existing dispute. So I rather refrain from mentioning about Section 9 cases because you have so far too many cases. I've already dealt with a multiple number of topics in this. But this case was different. And that is the reason I am bringing it to you. You will find this in topic number, I suppose, 109, if I'm not wrong, 108. Now, what it says is very important. The creditor can always transfer its assets to an assignee, but borrower cannot transfer its liability or debt to a third party. The creditor can transfer the borrower, but the borrower or assignee, borrower cannot transfer the liability. So transfer of asset is possible. Transfer of liability is not possible. The cases of Mohammed Zahir versus Ashu Agencies and another company appeal so and so NCLAT judgment. Now, in this case, what happened was a party was it's essentially dealing with a share purchase agreement, and CD and what happened was the corporate debtor had assigned its liability to another company. And they said, and this was recorded in the balance sheet of the operational creditor also. This was recorded in the balance sheet of operational creditor also. But the operational creditor later came and instituted Section 9. So, in this judgment, you will find that NCLAT has touched upon Contract Act, because this is basically Contract Act, Section 41, Section 63, Section 62. So this is a very, very interesting read and extremely important judgment, and because there is every possibility that you could be coming through this. I mean, this kind of scenario can always happen. And since this website is not just for insolvency professionals, but for the entire fraternity, it's necessary. Diversity of knowledge is most essential, and more flexibility in the knowledge, in the wisdom, is of extreme importance. So I stop the screen share here. and take you to the slide share, which I have. The slide is prepared by me for your easier understanding. Now, I have already read the topic. The creditor can always transfer its assets to an assignee, but a borrower cannot transfer its liability of debt to a third party. So, this particular entire case of the appellant is based on a letter dated 36/2018, written on behalf of Ashu Agencies to management of Al Dua Food Processing Private Limited. Some confusions is around a letter. The adjudicating authority in its impugned order has noticed that the said letter 36/2018 is disputed. Adjudicating authority further held that the letter itself cannot extinguish the liability of the corporate debtor. Why? Because a borrower cannot transfer its liability. As per CD, operational creditor having accepted and having given no objection for the transfer, its debt balance to MK Overseas Private Limited liability of the TD stood extinguished, and the OC's claim, if any, was against MK Overseas Private Limited, not against the CD. Even if the letter of 36/2018 is accepted, written on behalf of the operational creditor, and is treated as an agreement, the agreement being without consideration is void. That is the basic presence of contract act. Now you transfer your liability to another party for what? So there has, even if to a group company, but it has to have a consideration. So just like that, you make pass a journal entry and transfer the book that's transfer your sundry creditor to another company. That's not on. That goes against Section 41 of the Code. Present is a case where a corporate debtor cannot be held to be discharged by virtue of Section 41 of Contract Act 1872. The present case is not a case where Section 63 can be held to be applicable. The operational creditor has neither remitted, wholly or in part, the performance of the promise made to him, nor has it extended time for such performance or have accepted any satisfaction. So that means the debt remains. There has been no satisfaction. The goods were supplied. The goods were supplied which has been received and utilized. It was not even pleaded on behalf of the corporate debtor that the amount is not due. Rather, the corporate debtor itself in its pleading has claimed that an amount of 2,47,69,431 was due and payable to the operational credit. So money was due. Corporate debtor accepted that yes, 2,41,047,000 I'm supposed to pay to the operational credit, which I did not. I have not done. I've transferred it to another company in the group and should take it from him. The creditor, then comes the punchline. The creditor can always transfer its assets to an assignee, but borrower cannot transfer its liability of debt to a third party. Why? Because there is no consideration, and without consideration, a contract is void. There being no debt and there being debt and default committed by the corporate debtor, adjudicating authority has rightly admitted Section 9 application. So though this is a judgment under Section 9, but this is very different. You cannot call it as a pre-existing dispute. This is very relevant. This is absolutely a new thing, and we have lots to learn from this. So I would request my readers or my viewers, please go through the excerpts of the judgment, which is present in the Guide to IBC website, and enrich your knowledge. With this, I take you over to the next slide.
Viewers, we are in the middle almost. We have covered 50% of the judgments. Having said that, we select some judgments which look important to us. But in my point of view, all judgments are important. So I would recommend my viewers, please go through all the judgments. The website is updated every day with judgments. So please go through the website and see the new judgments which are coming in, which will keep you abreast with the developments taking up in the IBC matters. So with this, I take you over to the next part of the video.
Viewers, there has been a great number of changes, an entire approach with respect to valuation of assets in insolvency process. This has been introduced on 25th of February 2026. Now, as the situation stands, it doesn't involve a particular case. But it is necessary for you to understand. Why I'm doing this particular presentation is because I see that I have received calls from number of valuers, number of corporate debtors, and number of banks and financial institutions as to how this valuation process is going to run. So it is, and in general, there is a little bit of confusion moving around. So I thought that it is better to do a slide on this. So this is interesting. I suppose most of you know how to navigate the website. So I'm not going into the website. I'm straight going into the topic, going into the relevant regulations. And this has affected not only CIRP process, CIRP, liquidation, voluntary liquidation, personal guarantor, especially bankruptcy, fast track, and then prepackaged. So automatically cyclic effect is there. I mean, rippling effect is there in everyone. So we are going to concentrate on CIRP process because that is the main thing. Now, change has been brought, a new section, new regulation has been inserted in regulation in the way of regulation 2HB, which is very important. Now, fair value means the estimate of realizable value of the corporate debtor on the assets of the corporate debtor, as the case may be. Now, mark the words. This is important. If they were exchanged on the insolvency commencement date between a willing buyer and a willing seller in an arm's length transaction after proper marketing and where the parties had acted knowledgeably, prudently, and without compulsion. That means what? There's a sea of change. No international international valuation standards. What it is saying is, if the value, it is the estimated value at which the assets, if the assets could be exchanged between a willing buyer and the corporate debtor on the commencement of insolvency commencement date, and the buyer and the seller were acting at arm's length and with full marketing effort being done, they're acting prudently and without compulsion. Explanation is what? The estimated realizable value of the corporate debtor shall be computed after taking into account the total estimated realizable value in the assets of all the assets of the corporate debtor, including but not limited to tangible and intangible assets along with their underlying synergies. Now, intangible assets along with synergies, this is entirely a different thing which has been introduced in this demarcation. So this is very important. Even the intangible assets are coming into, so goodwill also comes in. Intangible assets. Now, what are the asset class? Now, we have to understand herein, you will find in Regulation 35, they have referred to companies registered valuers and valuation rule 2017. In the rules, rule 2 definition 21C, asset class is defined as asset class means a distinct group of assets such as land and building, machinery and equipment displaying similar characteristics that can be classified and require separate set of valuers for valuation. So that means what? There is no change. Even now, 3 sets of valuers will be there. One is land building, one is plant machinery, and one will be SFA. That is securities and financial assets. So this is absolutely clear. But we have to keep in mind that intangible asset issue has to be there and exchange value on the commencement of insolvency date, CIRP date. Now let us come to Regulation 35. Now what does it say? The fair value and liquidation value shall be determined in the following manner, namely, fair value and liquidation value shall be determined in the following manner, namely, A, a set of registered valuers. Now the word set has been introduced. The set of registered valuers appointed under Regulation 27 shall comprise of one registered valuer for each asset class, the corporate debtor, and within each set, one registered valuer shall be designated as the coordinating valuer for the set by the resolution professional in consultation with the committee for computation of fair value of the corporate debtor. So here the stress is on fair value. And for each asset class, there will be, of the two valuers, one will be a coordinating valuer. This was not there earlier. Explanation. For the purposes of Clause A, asset class means the definition provided under the Companies Registered Valuer Rules 2017, which we have just now gone through, dealt with. B is what? The resolution professional shall facilitate a meeting wherein registered valuers, including the coordinating valuer, shall explain the methodology being adopted to arrive at the valuation to the members of the committee before computation of estimates. So the meeting between COC and the registered valuers will take place before commencement of valuation process. So this is also something new. See, each registered valuer shall, after physical verification of the inventory and fixed assets of the corporate debtor, submit to resolution professional and the coordinating valuer of the respective set, a report on the fair value of the assets of the corporate debtor and the liquidation value computed in accordance with such valuation standards and as notified by the board through circular. So earlier report was coming only to resolution professional. Now the report will go to coordinating valuer and the RP. D is what? Each registered valuer shall, after physical, okay, D, we are coming to D. The coordinating valuer of a set shall compute the fair value of the corporate debtor after considering the fair value of assets as computed by the registered valuers within the set, along with the underlying synergies, and submit the same to the resolution professional. So, along with underlying synergies, this is a very, very important thing. So, this has been newly introduced. The resolution professional may appoint a third set of registered valuers for submitting an estimate of the fair value and liquidation value computed in the manner provided under this regulation, where the two estimates of fair value of the corporate debtor or liquidation value are significantly different. Now, earlier you will remember it was only liquidation value. Now they're mentioning fair value and liquidation value are significantly different. The committee proposes to appoint a third set of registered valuers for reasons to be recorded in writing. So committee has the relaxation. Whether the valuation is different or not, they can appoint a third set of valuers. But for the RP, there has to be a significant difference in the value, which will prompt the RP to appoint a third set of valuer. Explanation. For the purpose of Clause E, significant means a difference of 25% or more in the fair value of the corporate debtor submitted by the coordinating valuer for or the liquidation value as the case may be. So you can see the focus has changed. It is no more the liquidation value alone. It is fair value and liquidation value, both. The average of two closest estimates for the fair value submitted by the coordinating valuer shall be considered as the fair value of the corporate debtor, and The average of two closest estimates of liquidation value submitted by the registered valuers in each asset class shall be considered as the liquidation value of the corporate debtor. This is simple. A registered valuer shall prepare a valuation report and maintain such documents as per the format notified by the board through circular. Fine. Now, when we come to sub-regulation 2, it says, after receipt of the resolution plan in accordance with the code and those regulations, the resolution professional shall provide the fair value, the liquidation value, and the valuation reports to every member of the committee in electronic form on receiving an undertaking from the member to the effect that such member shall maintain confidentiality in terms of subsection 2 of section 29. The resolution professional and the registered valuer shall maintain confidentiality of fair value and the liquidation value. So you can see that the concept of valuation has gone through a sea of change. So everybody in the entire fraternity, this is not aimed at insolvency professionals alone. This presentation, as I mentioned, it looks at the entire fraternity, which includes corporate debtors, the COC, the operational creditors, the corporate, the home buyers, everybody. But they should understand that the concept of valuation has entirely changed, and it has become significant that both fair value and liquidation value is important. And not only that, the valuation has to take into account, firstly, the exchange value at the commencement of the CIRP process. Secondly, not only tangible assets, but intangible assets also, and the synergy effect. So this has become really a dynamic regulation, set of regulations, which you should know. I would recommend you to go to the website and see, but had I gone into the website and taken this presentation would have taken longer. So I think for that, I should be excused. So with this, we move on to the next slide. Viewers, we are on the screen of section 21 of IBC, which deals with committee of creditors. We are coming to a very interesting topic number 22, which says that a COC is a mere collective of independent financial creditors. And despite its formation, it does not purport to efface the independent identity of members constituting it. The cases of Committee of Creditors of Think and Learn Private Limited versus Riju Ravindran and others, BCCI was also a respondent to this case. This is a Chennai NCLAT case, and of February late half, which I could not cover in February presentation. In this, the NCLAT looked into the topic of whether COC can be sued, or whether a suit can be filed by COC, or COC can file a suit. So this is a very tricky question on which NCLAT dealt. And I reckon this is a different kind of a topic. And we should all go through this. With this, I take you over to the slide which I have prepared for you. Now, the judgment says a COC synonymously, or COC is synonymous with partnership firm, a compendious term law recognizes to refer to the partners who constitute it. But it is not a partnership firm. It is neither a society. The expression committee of creditors is not defined in section 5. It finds reference indeed in its origin in section 21 of IBC. Though insolvency professional, RP, IRP, they are all defined in section 5. COC has got no definition of its own. So it is not part of the definition. It finds its origin in Section 21 of IBC. Principally, COC by default is a group of financial creditors which, in terms of Section 5, subsection 7, are those to whom financial debt is defined under Section 5, subsection 8 and is owed by corporate debtor. We know that COC mainly comprises of financial creditors. If operational creditors have got dues over 10% of the total dues, then they come in the committee of creditors. So essentially, let us, that is an exception. So essentially, COC is a collection of financial creditors. Now we come to the interesting part of it. The COC is a mere collective of independent financial creditors. And despite its formation, it does not purport to efface the independent identity of the members constituting it. A COC is not a committee spontaneously created by the volition of financial creditors, but is formed in deference to the statutory conceptualization. This is a tremendously important phrase. It is formed in deference to the statutory conceptualization. Under the scheme of IBC, the COC is conceived as a statutory contrivance, an engine that runs the entire insolvency resolution process. Through whom? Through the RP. But who runs it? It is the COC. The IBC may require financial creditors to go for a huddle, yet it does not aim to build any team spirit within the COC. Every individual member maintains their individuality. A member of COC today can assign the debt to somebody else, and somebody else comes. So there is, even if financial creditors go into a huddle, it does not build a team spirit within the COC. So there is a convergence and divergence, both taken together. Since COC is a statutory body, a decision-making entity, to deny its legal existence for all purposes merely because it is neither a juristic person might akin to throwing the baby out of bathwater. Now, if you remove the main COC, the main body, you don't consider, because it is not a juristic person, and you throw it out of water, that you don't have a locus, the entire IBC goes into a toss. The COC constitutes, the code constitutes COC and RP as entirely different entities and have assigned them different roles and specific responsibilities. The RP does not act as an agent of COC, but merely complies with the IBC, what IBC directs. So this is a phenomenal judgment, and I feel everyone should go through this. This is very interesting. With this, we move on to the next slide. Viewers, we are on the screen of Section 66 of IBC. Section 66 deals with fraudulent trading and wrongful trading, fraudulent transaction and wrongful trading. This has two parts, Section 66.1 and 66.2. Now, we are coming to, so essentially you can make out that this section deals with something which is fraudulent or wrongful. And this is the penal section. Now we are coming to topic 38, which says that when technical services were rendered legitimately, by the erstwhile management to keep the corporate debtor running as a going concern, the tenability of the same transaction cannot be doubted or viewed suspiciously. The cases of Mr. Rakshit Dhirajlal Doshi and another versus Chirag Shah, liquidated, company appeal so and so, NCLAT judgment. This judgment of 2nd March 2026. Now, why I have picked up this case is, though this is Section 66, it deals with essentially whether a fraudulent intention was there or not. We have earlier also read sections, I have covered it in that any payment to a related party does not constitute a fraudulent trading. If it is done in the ordinary course of business, this is fine. And that directors are employees of the company, if they are whole-time directors. So payment of salary payment of salary need not be for fraudulent intention. So this is a small case, and I would like to tell my viewers one thing, that don't go by the length of the judgment, that don't go by the length of the number of pages it covers. Could be a 3-page judgment is vital. It could be a 300-page judgment, maybe giving you some details. So what is the essence that is to be seen? So with this, we move on to the slide. What I have told you is that there is only topic is one, that when technical services were rendered legitimately by SQL management to keep the company as a going concern, the tenability of the same transaction cannot be doubted or viewed suspiciously. There should be another heading. Routing of revenue generation through sister concern of the city is a standard business practice. This is viewed as an attempt, cannot be viewed as an attempt to siphon off funds from the sister concern for any such transaction to be stamped with fraudulent intent. So this is a very, very vital thing. And in any case, if you are getting money from a sister concern, what's wrong in that? You are not giving money to the sister concern. You're getting money from sister concern to run the business. So what's wrong? So in this case, what happened? The total claim received from the appellant was for their remuneration of 54.36 lakhs towards salaries for the period 2019-20 and 2021. Now, when managerial services were rendered in the ordinary course of business by the suspended management, Section 66 cannot be said to visit the remuneration transaction for the financial year 1920 in the absence of strict proof of demonstration of intent of defraud. The RP held that the amount were withdrawn on 30/6/2022, while CIRP admission was 1/7/2022. That is just a day in advance. When technical services were rendered legitimately by erstwhile management to keep the corporator running as a going concern, the tenability of the same transaction cannot be doubted or viewed suspiciously. Hence, the claim of the RP that these transactions are preferential or wrongful, keeping in mind proximity of the check withdrawal date is to the insolvency commencement date, is entirely misplaced or factually incorrect. Yes, they have drawn money. They see that the company is going to be put into CIRP, they won't be able to draw money. So they have drawn money. It is their money which is due payable to them. So where is the fraudulent intent? A money which is legitimately due has been drawn. Right. So just because of the proximity of the CIRP commencement doesn't make it fraudulent. Okay. In respect of withdrawal of 2 lakhs made by suspended management for the remuneration for the year 1920, for which the check was admittedly cleared after CIRP admission order, the factum of having knowledge of CIRP was imminent. So this was held to be a preferential transaction. Something will remain. The withdrawal of said amount of 2 lakhs are of the considered view that this sum deserves to be refunded to the account of the corporate debtor. Fine. Routing of revenue generation through sister concern of the CD is a standard business practice. This in itself cannot be viewed as an attempt to siphon off funds from sister concern, and for any such transaction to be stamped with fraudulent intent. What is the lookout of the erstwhile management? To keep the company as a going concern. If they're not getting money from outside, if the sister concern is generating money, they have taken money, what is the fraudulent intent? There was also another point which was covered in this, was that the RP had pointed out that TDS was not paid. So the court came down and said that, well, if the company is in financial distress, such things can happen. TDS has not been deducted. So what? That is the lookout of the income tax department. They have not deducted TDS. That will be looked at. This is not in the that does not come in the purview of Insolvency Bankruptcy Code. They have taken money. There is no fraudulent intent in that. If TDS has not been deducted, well, income tax is going to take care of that. It is cannot be held as fraudulent intention. The inability of CD to meet tax obligation during the period of financial distress when placed in juxtaposition to the payment of remuneration of managerial services cannot form a ground to demonstrate any dishonest design. So though this is a section 66 thing, but the court has denied, court has set, court has not, court has set aside the order and stated that this does not qualify as a section 66 petition. So this judgment is completely different from what we see normally. So this is very important. And I thought this is worth being noted. And that is why the presentation. With this, we'll move to the next slide. Here on the screen of section 95, which deals with the application by creditor to initiate insolvency resolution process against personal guarantors. Or you can say individual, but individual hasn't, the regulations have not come. So essentially, all the process pertaining to Insolvency Bankruptcy Code relating to personal, individual and partnership are essentially with respect to personal guarantors. Now, why this case is important, I'll come to that. This is topic 49. We need to consider the orders passed by Honorable Supreme Court in suo motu writ petition C number 3 of 2020 in recognition for extension of limitation. This is limitation pertaining to COVID-19 period. If you look at topic 48, it says that section 10A prohibits filing of application under section 7, 9 and 10 of IBC. And provisions of section 10A does not in any manner bar proceedings against personal guarantors under part 3 of IBC. Let us see 48. You will see that this case is of 2025. So this is a very recent case. But in the judgment of 49, which is more recent, State Bank of India versus Sanjay Baleshwar Rai, company appeal number so and so. It completely scores 180-degree apart. So NCLAT, an appellate authority, has taken absolutely contradicted itself with a particular approach, which should have been uniform. But this case was filed by State Bank of India for instituting personal insolvency process against Sanjay Baleshwar Rai. And it's a long judgment, and this is also featuring in section 238A, because 238 deals with limitation. So this is very much a matter of limitation. Because COVID-19 period, as you know, the Supreme Court had extended limitation between, what is the time? 15/3/2020 to 24/6/2001, and later it was increased up to 1/3/2022. So 15/3/2020 to 1/3/2022 was a period during which no claim could be enforced. No claim, rather to say no claim arising between this period, that is 15/3/20 till 24/6 till 1/3/22, could be, any proceedings could be moved in NCLT or any court for that matter. So, and this judgment is more important because it goes into the details of how one is going to calculate the limitation. for the purposes of limitation, considering the dates uh, when the claim was arising or was guarantee was invoked, based on that and keeping in view the suo motu order by Honorable Supreme Court, the court did almost a mathematical, laid a mathematical formula regarding this. So I would strongly recommend, as I always do, to my viewers to please go through the excerpts of the judgment. But with this, let me take you over to the slide which I prepared for you. So I've already told you about the topic, so I am not going into repetition of the same. It was State Bank of India versus Sanjay Baleshwar Rai. And you will see that I've put in a note that the case of Neeta Saha versus Asset Care Reconstruction Enterprises Limited, Company Appeal so and so, in which the court held that 10A prohibits filing of application under 7, 9, and 10 of IBC. Provisions of Section 10A does not have in any manner proceedings under personal guarantors. So this is contradicting the view approached by NCLAT in a recent but earlier judgment. Now let us come to the judgment part of it. Honorable Supreme Court held that the balance limitation left on 15/3/20 would become available with effect from 1/3/2022. That's the bottom line. 15/3/20 to 1/3/2022. Any claim arising in between that period will have to enjoy the entire period of COVID-19 limitation. So even if that was maturing on 28th of February, it should get the benefit of COVID-19 period, that is 15/3/20 to 1/3/22. Now, how that is done? Now let us come to this entitles applicant to claim actual balance period of limitation remaining available and with effect from 1/3/2022. That means after 1/3/2022, the balance period of limitation which was left can be availed. And in this case, we need to notice that on 15/3/2020, how much balance was for limitation? That is from 15/3/2020 to 24/6/2021. That was the time when the demand was made. How much period had elapsed? Which period has to be excluded while computing the balance period of limitation? There were two cases actually. There were two matters which were clubbed together and were being adjusted by the court in the same judgment. Now, in one case, from 15/3/2020 to 24/6/2021, that is the period I told you that when the demand was raised, the PG was invoked. A period of 1 year, 3 months, and 9 days had elapsed. So 15/3/2020 to 24/6/2021. Between that 1 year, 3 months, and 9 days had elapsed. Thus, on 1/3/2022, the balance period of limitation available is 1 year, 3 months, and 9 days. So from 1/3/2022, he should get that period. So thus, from 1/3/2022, adding the balance period of 1 year, 3 months, and 9 days, the date comes at 10/6/2023. So even if the application is filed of little before 10/6/2023, it won't be barred by limitation. Similarly, in company appeal number so and so, we need to look into the period which elapsed between 15/3/20 to 18/3/2021, which comes to 1 year and 3 days. Thus, the balance period available was 1 year and 3 days with effect from 1/3/2020. And when we add the balance period of 1 year, 3 days from filing an application, the period will come to end on 4/3/2023. The company appeal number so and so. Admittedly, the application was filed on 24/1/2023. That is the first one. And the company appeal so and so. The second one was filed on 25/2/2023. That is well before 4/3/2023. The application filed by SBI against respondents' personal characters cannot be said to be barred by time. The adjudicating authority in the impugned order committed an error in observing that time available was 90 days period up to 35/2022. So the adjudicating authority committed an error. So the matter was remanded back, order was set aside and remanded back to NCLT. So this is actually a yardstick because many of us, COVID has gone long back in 2020, but it is still with us. It is still with us as much as possibly. God knows up to how long this is going to stay. I wonder what happens if somebody's claim got matured on 28, just before 1/3/2022, say 28 to 2022. In such case, he should get the entire 2 years. So this goes up to 2024. 2024, say 26th of February or 27th of February. And 2024, was it a leap year? No. Yes, it was a leap year. So that factor also we have to consider. But this is no doubt an interesting case. And that is why this is important. I would recommend the viewers also to see 238A, topic 51, because there are other cases also, but this case is also there, and it will be an interesting read. So with this, I take you over to the next slide. Viewers, we are on the screen of Section 21 of IBC, which deals with Committee of Creditors. We are coming to a very interesting topic number 22, which says that a COC is a mere collective of independent financial creditors. And despite its formation, it does not purport to efface the independent identity of members constituting it. The cases of Committee of Creditors of Think and Learn Private Limited versus Riju Ravindran and others, BCCI was also a respondent to this case. This is a Chennai NCLAT case and of February late half, which I could not cover in February presentation. In this, the NCLAT looked into the topic of whether COC can be sued, or whether a suit can be filed by COC, or COC can file a suit. So this is a very tricky question on which NCLAT dealt. And I reckon this is a different kind of a topic. And we should all go through this. With this, I take you over to the slide which I have prepared for you. Now, the judgment says a COC is synonymous with partnership firm. A compendious term law recognizes to refer to the partners who constitute it. But it is not a partnership firm. It is neither a society. The expression Committee of Creditors is not defined in Section 5. It finds reference, indeed, in its origin in Section 21 of IBC. Though insolvency professional, RP, IRP, they're all defined in Section 5. COC has got no definition of its own. So it is not part of the definition. It finds its origin in Section 21 of IBC. Principally, COC by default is a group of financial creditors which, in terms of Section 5, subsection 7, are those to whom financial debt is defined under Section 5, subsection 8 and is owed by corporate debtor. We know that COC mainly comprises of financial creditors. If operational creditors have got dues over 10% of the total dues, then they come in the committee of creditors. So essentially, let us, that is an exception. So essentially, COC is a collection of financial creditors. Now, now we come to the interesting part of it. A COC is a mere collective of independent financial creditors. And despite its formation, it does not purport to efface the independent identity of the members constituting it. A COC is not a committee spontaneously created by the volition of financial creditors, but is formed in deference to the statutory conceptualization. This is a tremendously important phrase. It is formed in deference to the statutory conceptualization. Under the scheme of IBC, the COC is conceived as a statutory contrivance, an engine that runs the entire insolvency resolution process. Through whom? Through the RP. But who runs it? It is the COC. The IBC may require financial creditors to go for a hurdle, yet it does not aim to build any team spirit within the COC. Every individual member maintains their individuality. A member of COC today can assign the debt to somebody else, and somebody else comes. So there is, even if financial creditors go into a huddle, it does not build a team spirit within the COC. So there is a convergence and divergence, both taken together. Since COC is a statutory body, a decision-making entity, to deny its legal existence for all purposes merely because it is neither a juristic person might akin to throwing the baby out of bathwater. Now, if you remove the main COC, the main body, you don't consider, because it is not a juristic person, and you throw it out of water, that you don't have a locus, the entire IBC goes into a toss. The code constitutes COC and RP as entirely different entities and have assigned them different roles and specific responsibilities. The RP does not act as an agent of COC, but merely complies with the IBC, what IBC directs. So this is a phenomenal judgment, and I feel everyone should go through this. This is very interesting. With this, we move on to the next slide.
Viewers, we have come to the end of this presentation. I hope you liked it. Please comment. We look forward to your comments. We look forward to your likes because they motivate us. If there are some observations you have, please let us know so that we can improve ourselves. So we look forward to coming back to you again towards the end of this month. Thank you. Have an excellent 15 days fortnight ahead. Bye for now.